Morning, everybody. Welcome, welcome. Thanks so much for joining us. Myself and Ruth are going to take you through a roller coaster of redundancy processes and procedures today. There's a lot to get through, so it'll be a bit of a canter through. I don't know how all of you are finding the sort of current furlough arrangements. I have to say, in our practice and experience, we're finding that despite the extension of furlough through until the end of March, actually a lot of our employers are already starting to do their restructures, do their redundancy plans. They're not really waiting around until furlough at the end of March. So we thought that this was a well-timed reminder of some of the basics of the requirements for a fair redundancy process. For those of you who don't know me, I'm Linky Trott and I head up the employment team at Edwin Co. Ruth is a colleague of mine, she's a partner in the team, and we're going to be double-handing it so you're not bored with one voice this morning. I wonder, Tanya, could we go through to the next slide, and I think just sets the agenda of what we will be looking at. So that sort of sets out the broad headlines: when is a role redundant, the procedure to be followed, identifying the right pool, selecting objective criteria, furlough, the inevitable question of furlough, those potential risk areas we'll look at. So these are sort of common things that we see in practice which can trip people up. I'm going to touch on very, very briefly collective consultation. As I've said there, it's a separate seminar in itself. But it'll just act as an aid memoir to sort of signpost for you when maybe you should be thinking of collective consultation as opposed to individual consultation. And we'll be looking at how to minimise the risks of disputes with disgruntled employees. It is a difficult process for employees to go through, and when to engage an employment lawyer. So I'm going to kick off. I think, Ruth, you're going to leave us, and then you'll come back when my bit is done. So starting off with, when is a role redundant? I anticipate many of you will be pretty familiar with this, but in essence, it's when you've got a whole business closure or a partial business closure. So one site is closing, for example, or where there is a diminished requirement for the number of employees that you have to do a particular job. And if that's reduced, then that is will fall within the statutory definition of a redundancy situation. And it's a reduction in the number of employees. Tanya, if you could just take me through to the next slide. I'm going to sort of touch on some of the issues that we see quite a bit in practice. The first is, and clients ask about it a lot, is what about a mobility clause? So this is a circumstance where the contracts of employment have a mobility clause allowing the employer to move the individual to a separate place, a different place of work. And you've got two sites, one of the sites is closing. Can you avoid dealing with a redundancy by saying, well, look, actually, I'm going to exercise the right that we have under your contract of employment to transfer you under a mobility clause? And of course, the lawyer's answer, which I know is incredibly unhelpful, is maybe. It really depends on the circumstances, because there is an implied term into the contract of employment that says mobility clauses have to be exercised reasonably from the perspective of the employee. So if, for instance, you have two sites in London and one of the London sites is closing, it may well be a reasonable management instruction to say to those employees, if you are able to redeploy them to the other site, that they have to move to the other site under the terms of their mobility clause, which would mean it's not a redundancy. If they refuse to move, you could approach it on the basis of a dismissal for failure to comply with a reasonable management instruction. But it's judged at the subjective sort of assessment of the employee. So if, for instance, the other site is in Glasgow and you're asking them to relocate to Glasgow, that may well be an unreasonable exercise of a management instruction under the mobility clause to move to Glasgow, and therefore you would be approaching it on the basis of a place of work redundancy with the closure of a site in London, for example. Frequent mistakes, and these are really just things that I've come across in practice, so I thought I would highlight them. Very often employees during a redundancy consultation process say, well, I've never been busier. You know, it's just complete rubbish that this role is redundant. I'm busier than I've ever been. And I think that the thing to remember in those circumstances is that it can include an anticipated reduction in work. And we've got a number of clients who, during the pandemic, they had a lot of pipeline work for everything that was done prior to lockdown. They then did that pipeline work. Sales is a very good example. They did all of that during the pandemic. And then, of course, because their sales teams haven't been able to get out and about and, you know, knock on doors and go and see people, they can see that coming for sort of March or April next year, there is a lack of pipeline and there will be a diminished requirement for the number of employees. So I think it's sort of giving employers confidence to say, look, you can be robust to say, you know, this is an anticipated downturn in work. And obviously you would need to produce the stats that demonstrate that downturn in pipeline. The other thing that I come across a lot is that it's roles that are redundant, not employees. And this happens particularly in sort of smaller organizations where some poor chief executive is trying to manage the process without a dedicated HR person to sort of steer them through the possible pitfalls. And they will fire off an email saying, we need to get rid of Fred. I think we need to make him redundant. You know, please could you start the process? And of course, that's immediately started off on the wrong foot because you've identified Fred. And it means that you're sort of on the back foot for then being able to identify the role that you don't need and the sort of business rationale for why you don't need it, whether or not Fred should be put into a pool, should he be pooled and have objective selection criteria, or is he in a pool of one, and then going through the fair consultation process with him. And of course, if the initial email says we need to make Fred redundant, gets you off on the wrong foot, it makes it quite difficult to get through a fair process. There is a bit of backtracking that can be done, but I think you need to encourage those decision makers within the business, the board, to look at it in terms of roles. The HR partners that I work with, they're extremely experienced at this, and they usually approach it by way of organizational charts, a sort of before and after, where you have, you know, roles and responsibilities without particularly names on it, and assessing with the board whether or not any particular role or level of management, or however it's going to be restructured, is required going forward. And that, I think, leads me neatly into the next bullet point, which is circulating disclosable internal memos. So the CEO's memo saying we need to make Fred redundant, that is a disclosable document. It's not covered by any legal professional privilege. And if Fred challenges his redundancy and you end up in employment tribunal proceedings, then that email will be a disclosable document. Indeed, Fred may make a data subject access request. And certainly when I see individuals in these circumstances, one of the first things we do is fire off a data subject access request, because it can produce a lot of very interesting documents. So caution your boards about putting things on email and identifying individuals on email at the start of the process, because all of that sort of thing would be disclosable in the event of proceedings. The other thing that I see quite a lot is not approaching it with an open mind. Ruth will take us through the process in a moment, but one of the fundamentals is that there is an obligation to consult about the proposal to make that role redundant. It's not a question of whether or not there's just redeployment. Very often I see consultation processes which just have looked at redeployment. You've got to actually also consult on the decision to make the role redundant. And the tribunals live in this sort of slightly idealistic world where they would say, well, for instance, if you had somebody who was doing a role full time and you just saw there was a diminished requirement, you know, unless you consulted with them, they may well have said to you in response to the proposal to make that role redundant, well, actually, I've always wanted to do some studying. I'd like to go down to 2 days a week. I think there is enough work to justify 2 days a week. And then I'll do studying 3 days a week. And the tribunal will expect the employer to have considered that and rejected it maybe for business rationale reasons, but nonetheless are expected to have considered it. Tanya, if we could go on to the next slide. I'm going to hand over to Ruth, who is going to take us through procedure to be followed. So over to you, Ruth.
Thank you, Linky. So the next question, as I say, is the procedure to be followed in effecting these redundancies. I should start off by saying the procedure that we've set up there is actually where is applicable to individual consultation, so where you're making less than 20 people redundant. Linky will touch later on collective consultation, which applies to more than 20 people. But the first thing to say is there are no statutory rules, as I'm sure you know, for how you fairly effect a redundancy. It's all in the case law, which has been distilled over the years. And probably the major case is the House of Lords case from 1987 called Polkey. And that set out what an employer must do to carry out redundancies fairly. And it's set out there on the screen. Warn and consult about the proposed redundancy. This obviously requires at-risk letters, consultation meetings. Then there's this general requirement to adopt a fair basis to select employees for redundancy. And the things that are required there are selection pools, the selection criteria, making sure that the decisions are fair and offering a right of appeal. And then the final element that Polkey requires is to consider suitable alternative employment. So next slide, please, Tanya. So consultation is the key to success of this process. It sounds like a simple concept, but in practice it's actually quite tricky to get right. One of the key things is that the employer must have an open mind when they're looking at this and actually consult people at a formative stage. So we always go on about a redundancy proposal, and it must definitely be put as a proposal. An employer cannot just present a fait accompli saying, well, you know, these are the people that are going to be made redundant. So I do appreciate many employers find the consultation process very uncomfortable, cumbersome, and it's time-consuming. And having made the difficult decisions in their own minds and having thought about it, their employers are often very impatient to just get on and implement the proposals and get it over with. But genuine consultation with staff can result in constructive feedback, which can change proposals, and it can actually avoid the need to make redundancies. So it can be a beneficial process if undertaken correctly and in good faith. And so bear that in mind when you're doing it. So an effective consultation process will set out the proposals and set out sufficient information to enable them to understand what is being proposed and why, and allow employees to make alternative suggestions. You've also got to allow adequate time for employees to respond. Now, I know lots of employers like to give an at-risk letter and have the first consultation meeting the next day to just give employees more information. Other employers like to allow 3 or even 5 days before the first consultation meeting to allow people time to consider what's been said. To some extent, it's a matter of personal preference and also how complicated the proposals are and how much time people need to think about their questions and what their situation is. So, and the third, or the last bullet point on that slide is that an employer must give conscientious consideration in responding to the consultation. So you can't just say no, no, no. You know, in practice, this means the employer being able to explain why the employee's suggestions can't be implemented, or to avoid the redundancies, or to do the reorganisation in a different way. Next slide, please, Tanya. So the next slide is about things that you need to consider in any consultation. Oh, Tanya, is it? Could we have the next slide, please? Oh, there we go. So things to include in the consultation. Well, the very first one is volunteers and whether any of the workforce wish to volunteer for redundancy. This can actually be a good way of reducing the number of compulsory redundancies. So it is something that should be addressed at the outset before the start of compulsory selection. One word of warning, when writing to employees to invite them to volunteer for redundancy, the employer must remember to reserve the right to reject applications for voluntary redundancy. Otherwise, you may find that all your best employees volunteer and you're left with those that you're not so keen to keep. So you must be able to reject applications if you need to. The next thing that must be included is employees suggesting ways of avoiding redundancy. Now, this should occur at the initial meeting once employees are aware of the proposals and that they are at risk of redundancy. So things that can include things like eliminating agency staff, reducing overtime, short time working, pay freezes, offering sabbaticals or unpaid leave, or as Linky mentioned, perhaps part-time working. If you've already considered any of those cost-cutting measures, then as an employer, you need to be saying that in your at-risk letter and informing them that you've already done certain things to try and reduce the necessity to make redundancies. But you know, that can be a fruitful stage in the consultation, and it can result in new ideas which may reduce the necessity to make compulsory redundancies. Now, the next one about commenting on the selection pool and the selection criteria. If you are an employer that recognises a union, there may be a recognition agreement which impacts on selection pools and selection criteria, and that will need to be taken into account at the outset. But if you don't have unions, then you should involve the employees, at least to some extent, in the selection pool and selection criteria. At least you need to tell them which selection pools they're in, and also what the selection criteria are, ideally before you apply them to them. Once you have applied the selection criteria, you do need to discuss the scores with the employees, give them an opportunity to challenge the assessment and explain any selection factors, which, for example, the manager analysing them may not be aware of. So, for example, if they've scored a 0 for speaking another language because the scoring manager is not aware of their language skills, if the employee is able to see the score they've been given, they can question it and say, well, hang on, in fact, I've got an A level in French or German or whatever, and should be given a higher mark. So this discrepancy between the score and the employee's actual abilities often occurs where the managers don't know the employees very well, or there's a wide selection pool, or there's a slightly different job role for which the employee is being considered. So that just illustrates how important it is to discuss the scores with the employee and get their feedback. Suitable alternative employment. Once the employer has actually gone through the selection process and the number of employees has been identified as redundant, the next step, and it is a separate step, is consideration of any suitable alternative employment that the employer may have available for the staff. Now, employers deal with this differently. Some employers are very proactive and will present vacancies to employees for them to consider. Larger employers often have their own intranet or other means of making vacancies available. So often that approach is to just inform employees of the available resources and leave them to apply for any roles that they would like to do so. The safest option here is for an employer to offer all available vacancies and leave it to the employee to decide which they consider is suitable for them. For employers in a group, best practice to offer all group vacancies and not just limit it to your particular company. A final word of warning, particularly when an employer is closing down a site and there's clearly no other alternative employment, it's important still that the issue of alternative employment is raised in the consultation meeting and recorded as having been discussed. It's not something which just should be considered by all parties as obvious. And then the final point I wanted to make here is about time frame. There's no legally prescribed time frame for consultation about redundancy for individual consultation, which is obviously different from collective. The time frame for appropriate consultation will depend on the facts of each situation. Generally, the shorter the consultation, the more likely it is that the quality will be called into question. Where there are a number of redundancies, often the time frame will, for purely practical purposes, have to be longer because of allowing time to have several meetings with each employee. But as a general rule of thumb, I recommend a minimum of 14 days for consultation. Next slide, please, Tanya. Right, selection pools, a cause of many headaches for employers. This is the starting point, really, when you're considering redundancies. And an employer generally, you'll be pleased to hear, has a fairly wide discretion because there are no fixed rules about how a selection pool should be defined, subject obviously to any collective agreements you may have with unions. So as long as the employer's choice is within the range of reasonable responses, an employment tribunal will not interfere with the choice of selection pool. But do bear in mind when you're doing this exercise that you will have to demonstrate that you've applied your mind to this issue and also to explain how the selection pool has been constituted. So I always recommend the starting point should be to consider what particular kind of work is ceasing or diminishing and to look at which employees actually do that kind of work. And that involves not only looking at their contracts and their mobility clauses, as Linky's outlined, but also what they actually do in practice, because we often find that contracts have gone out of date and people have changed jobs or the focus has changed. The other thing to look at is which employee jobs are interchangeable, possibly even with employees at other locations. So you will find that identifying a selection pool is more complicated where employees are multi-skilled and do different types of work, or at least can be required to do so under their contract. Another issue that's often overlooked is where employees have previously done other work in the organisation, where the work is low skilled, so low skills are more likely to be regarded as interchangeable. In situations like that, it's often safest to put all employees with interchangeable skills in the one selection pool. But having said that, creation of selection pools is very fact specific, and there is no legal requirement for the pool to be limited to those doing the same type of work. A final word about selection pools. There can be a selection pool of one in a situation where there is genuinely only one employee carrying out that particular role. So the next point is the galloping horse on the slide. That is a frightened horse galloping, which is relevant for my next point, which is the question at the bottom of the slide. Should you frighten all the horses by consulting all the employees in the selection pool, or should you just undertake the selection process and only consult or put at risk those who've been identified by the selection criteria as likely to be redundant? Many employers take the view that if you're, for example, cutting a team down from 10 to 5, they don't want to inform all 10 that they're all at risk. They prefer not to upset the 5 who will be staying. So what they do is take a risk and apply the selection criteria to, well, I suppose to all 10, but they only inform the bottom 5 that they're at risk of redundancy because they've been selected as the worst performers. So this approach can have the result of not frightening the top 5 horses in the pool, but it's not without risk. The obvious risk is that the person who's number 6 in the consultation process points out that the scoring for his performance is wrong, and he might go up by 5 points, for example. Now, this may mean he's actually out of the group of poor performers and means that who was formerly number 5, who was safe, should now be considered at risk. So, great care should be taken with this approach to ensure it's fair. And certainly where there are minimal differences between the scores on the cusp, you may be safest at least to include more people in the process. Generally, the smaller the selection pool, the better off an employer is to consult all employees in the pool rather than taking a risk and only consulting with those who've been identified as at risk. Next slide, please, Tanya. So, selection criteria. This is another area where there's prompts lots of litigation. Creating objective selection criteria. Again, the employer has quite a degree of flexibility here, unless, of course, you're constrained by a collective agreement with a union, which again may specify the basis for selection. If so, then that has to be discussed with the union. But the basic requirements for selection criteria is that they must be relevant to the role being done, objective, and capable of independent verification. This means that ideally they must be measurable by objective means and not just a manager's personal opinion. So this measurement usually comes from things like personnel records and appraisals. And often the selection criteria include matters such as the performance and ability of the employee, length of service, attendance records, disciplinary records, all those sort of measurable things. But try to avoid as much as possible subjective grounds, which I know many employers favour, things like employees who are best suited for the needs of the business or who have the best attitude. It is possible for subjective criteria to be acceptable if they are applied objectively, but this is a dangerous area on which advice should be taken, so proceed with caution. Now, talking about relevance to the role, now that's a matter of fact in each situation. When I'm drafting selection criteria, I always start with the job description for the role and base the criteria on that. It goes without saying employers should avoid criteria which are discriminatory, either directly or indirectly. The picture on the slide, a forklift truck, reminds me of an indirect sex discrimination case I was involved in years ago now. The selection criteria had been applied to warehouse workers and they required the ability to drive a forklift truck. And 5 ladies in the warehouse brought claims for indirect sex discrimination. And it emerged subsequently that the ability to drive a forklift truck was indirectly discriminatory to the women in the warehouse, as before my client had bought the factory, only men had been permitted to drive forklifts. And this men-only rule had been imposed with the backing of the union, who was now bringing the claim on behalf of the ladies. So that's a salutary lesson to think about your criteria and whether they are indirectly discriminatory to the workforce with whom you're dealing. So we're going to move on in a moment to look at an example selection criteria, in which you can see that weighting can be applied. Again, do bear in mind how you're going to justify the weighting. And commonly, elements of the selection criteria which are weighted more are those for performance and experience. So the other point, which I will come back to later, is when you are doing the scoring, do think about who is doing the scoring. And it's often best to have more than one manager who has knowledge of the relevant employee. So here's the selection matrix. The first page just captures relevant initial information, which will often be obtained from the HR records. One point there, you could consider including a box for previous positions held in the business, because that can help alert the manager to other skills that the employee may have. So, oh, sorry, next one. Yes, so there's the selection matrix. Very simple, basically length of service, performance, skills, experience, etc. Now, provision's been made for notes and queries to be put on the right-hand side. That is a really useful thing to do, so that the scorer can note down the evidence on which they've relied for the score that they've given. So if performance and skills are being judged on the basis of the last appraisal, then the manager would write in the under the notes, graded A at the July 2020 appraisal, or whatever other evidence is being relied upon. Often the performance, skills and experience elements are subdivided into different types of skills or experience. The one there is very simple. And you'll see there potential is suggested as a criteria. Again, that's one of those subjective criteria, difficult to objectively measure, so treat that one with caution. Next slide, please. So there, shows the scoring system, very simple. The thing to note here is that the manager's comments and the employees' comments and the fact that scores have been evaluated by one manager and reviewed by a second manager. Also that the employee has had a space to sign to say that they've agreed the scores. That can be very useful subsequently if the employee brings a claim. So I will now hand you back to Linky, who's going to talk in more detail about the issues with redundancy for those on furlough and the specific risk areas.
Thanks very much, Ruth. Yes, so I was just going to run through some quick issue, touch on furlough, and then some particular risk areas, potential pitfalls. This furlough slide has become less relevant. Oh, forgive me, knock at the door. This slide has become less relevant because Ruth and I were doing this seminar about 3 or 4 months ago when it was possible to get the furlough grant whilst somebody was on notice. And there were some horribly complicated provisions about, well, how much notice do you have to pay them? Do you have to pay them their furlough rate of pay or their actual rate of pay? And actually it was incredibly complex depending on the length of notice and interplay with statutory notice. All of that has fallen away because the position changed as from the 1st of December, and it is not possible to claim the furlough grant for people who are serving a period of notice. Now, you can still consult and go through the redundancy at-risk process with people who are on furlough leave, but when you've made your decision and you've issued your notices of termination on the grounds of redundancy, once they're serving notice, you can no longer claim the furlough payment. So they have to be paid as usual under their usual contractual terms. I put a sort of aide-memoire there just in terms of some practical considerations, because in practice, and I think, apologies, we've experienced it this morning, sometimes consultations over Zoom or other video platforms are subject to the sort of vagaries of people's Wi-Fi, and sometimes the signal drops in and drops out. And I think it's just helpful to think those things through in advance in terms of your sort of due diligence prep to maybe have an alternative to the video call consultation, if that's how it's going to take place. Maybe also have a telephone conference line if everything does drop off and nobody can see anyone or hear anyone. But actually, I quite like the video platform because it enables you to share documents as we're doing today. And it's usually helpful to have organizational charts where you're trying to describe the restructure that has resulted in the redundancy of some role, the sort of before, and this is the proposed after. And sometimes that's quite useful to share with individuals as part of that consultation meeting. Tanya, if we could go on to the next slide, please. So potential risk areas, and these are all things that we have come across in practice. I mean, it's inevitable that there is always going to be an employee who says that the redundancy is a sham, it's not the real reason for their dismissal, it's something relating to their age or their sex or, you know, a bullying manager or something like that. And, you know, you just have to sort of take that in your stride and deal with it head on during the course of the consultation process. I haven't particularly touched on the question if somebody raises a grievance during the redundancy process, but where possible, I think that might fall under the section of discuss it with your employment lawyers, because where possible, my preference is always to deal with the grievance as part of the redundancy consultation process. There are circumstances where that is not possible, but if it is possible, I think it's much more preferable to keep on track the redundancy consultation process. I've highlighted there maternity. I'm sorry to say that I do see quite a lot of it in practice, and I can sort of see how it happens, particularly where you've got a number of sites and there's, you know, one central services function where the HR team sit and they have to sort of deal across a number of different sites. Is that people on maternity leave do just get forgotten, and sometimes, you know, it's very easy, the communications are just not circulated to them. So it's an aide memoir. Again, put on your due diligence list, ask the specific question: have we got anybody who's on maternity leave, about to go on maternity leave, on adoption leave, because the rules sort of apply the same, just to make sure that nobody is missed off the list. And it is important because there are special protections under the Equality Act for those on maternity leave, those who are pregnant or those who are on maternity leave. It's called the protected period, and they have very, very specific protections under the Equality Act. If somebody is in the protected period and they are treated unfavourably, they can bring a claim for that unfavourable treatment, and they don't have to rely on a comparator. So a good example is where an employee is on maternity leave and they're not included in some communications. The person on maternity leave can say, well, look, that is less favourable treatment because I am on maternity leave. She doesn't have to compare her treatment to somebody else who wasn't on maternity leave. She can just say, this happened because I was on maternity leave, and that is unfavourable treatment. There is a case which was quite helpful, which acknowledged it was a simple administrative error and therefore not maternity discrimination, but it was very fact specific, and I'm not sure that it would be followed now. Maternity is also a case where the business rationale for the proposed redundancy and that individual selection will be examined much more closely to see if redundancy really is the reason for the dismissal, because maternity need only be a material factor. It doesn't have to be the only reason. It has to just be a material factor to give rise to a maternity discrimination claim. So the tribunals will examine the business rationale and the selection much more carefully, where somebody who is on maternity leave is in scope and or is ultimately made redundant. The other thing to be aware of is selection criteria. The big issue here really is in relation to absence. And if you're assessing performance, I've done it recently with a client in relation to a sales team, and they had one individual who was on maternity leave. And it's quite easy in sales to find objective statistics that Ruth was talking about, rather than a subjective assessment of their performance, because of course you've got all of their sales figures, but care must be taken to compare like with like. So you must take a period of performance where the individual who is now on maternity leave was actually at work. And in fact, it's embarrassing to say that the firm of lawyers, not us, I hasten to add, got this very wrong when they were assessing a pool of 2 individuals. And the one individual who was on maternity leave, they said, well, we can't assess her performance because she's on maternity leave, so we're going to give her the top score for that so that she's not disadvantaged by being on maternity leave. But of course, the other person in the pool was a man, and his performance was assessed, and he got 9 out of 10 instead of the 10 out of 10 that they gave the individual on maternity leave. And of course, he brought a discrimination claim and won, because he was subjected to a detriment by reason of that unfair selection. So the easiest thing to do, and what we did with my client, was we took a period of time over which they were both at work, they were both selling, and we looked at their selling statistics over that period for the purposes of scoring their sort of sales performance for that particular selection criteria. Also, an employee who is pregnant on or on maternity leave, so in the protected period, also has the additional protection in terms of redeployment, because they have to be preferred against any other candidate, over and above any other candidate, for any redeployment opportunity. It's one of the rare examples in the UK law where there is a positive obligation to discriminate in favour somebody who's on maternity leave. And the other quick aid memoir is just to sort of say in relation to statutory maternity pay, if at the date of their dismissal on the grounds of redundancy an employee has become entitled to statutory maternity pay, then notwithstanding the termination of their employment, they're entitled to continue to be paid that statutory maternity pay. Sick leave. Sick leave is another potential area which can cause difficulties. It dovetails also with disability discrimination, which I will come on to. But very often in practice, you issue somebody with an at-risk of redundancy letter, and the next thing you hear is that they've gone off sick and you've got a doctor's certificate for 2 weeks or something like that. Stress and anxiety. And I think it's reasonable to say, look, if it's a sort of 2-week period and there's no, particular business urgency in relation to the decision, then one should just pause and have the consultation period when they're back at work, have the consultation meeting when they're back at work. But if you get another medical certificate, I think that's the point at which you'll want to engage with the employee about finding an alternative means of having the consultation meeting. I also always think it's a great idea to go to occupational health in this instance, because occupational health will be your friend. I can't think of one circumstance in practice where we haven't asked our occupational health advisors to say what other means of, what other adjustments can we make to enable the individual to undertake this consultation meeting. And of course, there are lots of other means, and occupational health will usually spell them out for you. And that puts you in very good stead to say, right, well, we're going to make those adjustments to the process and we're going to get on with it. And usually that's things like representations in writing, or entitling them to have a family member or a trusted friend at the meeting with them, and then follow up with representations in writing. They're those sort of adjustments to the process. And occupational health is your friend. They will help. The only other word of warning which I've mentioned on the slide is where you have the employees have the benefit of a permanent health insurance policy, which is offered by the employer. The difficulty with those policies, they're fabulous policies. They're the ones that say, look, if you have a really long-standing, long-term ill health issue, then after a certain accrual period, it's usually about 26 weeks. If you remain unwell, the insurance company will step in and they will pay the employee's base salary at sort of 75% or 60%, whatever the terms of the policy are. And it's a fabulous benefit, and a lot of employers do provide it. The difficulty is that it creates it curtails the employer's right to terminate, because in terminating, you're effectively depriving the employee of what is a very valuable contractual benefit. And if you get it wrong, the employer can be the wrong end of a very, very large breach of contract claim, because an employee would say, look, I've got an incredibly bad health issue. I've got a client who's been on PHI for 8 years, and he has continued to receive 75% of his salary over that 8-year period. So you can see how the value of these breach of contract claims can multiply. You can do it, and you can make somebody redundant who is on PHI, but you do have to be very careful. You have to look at the particular wording of the policy, you have to look at the wording of the contract and how the benefit was provided originally. And I think that is a circumstance, because the sort of downside is quite high. Actually, it's pretty commercial to go and take some advice from your employment lawyer before actually terminating the employment of somebody who is on an accrual period or who enjoys the benefit of a PHI policy, just to sort of cross-check the process, the selection, the fairness and the contractual position. Tanya, if we could move to the other slide. Disability. So disabled employees have a right not to be treated unfavourably because of something arising from their disability. Arising from is the sort of legal wording in the Equality Act. Essentially, it's anything that is connected to their disability. One case example is where an employer gave 5 working days within which to lodge an appeal. And the employee lodged their appeal, I think, on day 10, and the employer refused to hear the appeal. And the employee said, well, look, that's disability discrimination. I have learning difficulties, or I have an anxiety disorder, and it took me longer to prepare my appeal. And therefore, applying this criteria that everybody has to do it within 5 working days puts me as a disabled employee at a disadvantage. And so you've got to adjust that criteria. Technically, it's called the PCP, the Provision Criteria or Practice, but essentially the employee is saying you've got to adjust that. So you've got to extend it for me to accommodate and ameliorate the impact of my disability. And this concept of PCPs and reasonable adjustments, so applying criteria and reasonable adjustments, is also relevant for the selection criteria. And an example might be, for instance, where one of your criteria is punctuality. And an employee during the consultation process says, well, actually, the reason I'm not punctual is because I suffer from an anxiety disorder and I find it difficult to commute into work during rush hour. Those days are long since gone, I know, but this is a real case example. And therefore, the reason that I am not as punctual and I sort of arrive slightly after my start time arises from my disability, and therefore you have to make an adjustment to that selection criteria in order to ensure I'm not disadvantaged. Now, adjustments only have to be reasonable. One would have hoped that if that was something that was happening within the workplace, something would have been adjusted already by way of consultation with the employee, maybe an adjustment in their hours. But if for the first time it's raised during a consultation process, then think about an adjustment to that particular criteria and the way in which you score it for that individual employee. Reasonable adjustments might also create another sort of positive obligation on an employer where you have a redeployment policy, for example. There is a case which has said that favouring employees who are disabled employees at risk of redundancy above non-disabled employees for the purposes of redeployment. They can't go above the maternity returners. Maternity returners are top of the pile, but it may be a reasonable adjustment to adjust a redeployment policy to prefer disabled employees over non-disabled employees if there is suitable alternative employment which they can be redeployed into. And then just touching on age, I think I did see one of our questions was, can you use last in, first out, or is that discriminatory? It has the potential to be discriminatory because it is possibly indirect discrimination, but you can use it in concert and in combination with a number of other criteria. We tend to sort of suggest that other criteria are set, and if you have a tiebreaker situation where you've got 3 people all on the same score, and actually you only need to get rid of 2 roles, whatever, then you can use last in, first out as a tiebreaker, and that's quite a good deployment of that criteria. There's also a Tower Hamlets case where somebody was disadvantaged by reason of pension retirements. They were on secondment and the secondment was coming to an end, and they were then going through this redundancy process with Tower Hamlets. And the organisation they were seconded to said, well, look, we can extend that secondment for another 6 months. And there was an internal memo, again, my word of warning about unguarded emails, all of which become disclosable. But an internal memo was saying, well, look, we're not going to agree to extending the secondment for 6 months because that means that he'll tip over the age of 50 and he'll be entitled to enhanced retirement pension rights. So let's just get on with the redundancy now. And of course, that was held to be a discriminatory on the grounds of age. Tanya, if you could just take me through to the slides on collective consultation. I raised this really as an aid memoir. It's a seminar in itself, I'm afraid, because it's a complex area. But just bear in mind, at any particular site, which is termed an establishment, if you have 20 or more who are potentially affected by a restructure and a redundancy, then you need to think about collective consultation and whether or not the collective consultation obligations have been triggered. Tanya, if you take us through to the next slide, it'll just show some of the further information. You have to elect employee representatives. You've got to notify the Secretary of State. I think that is if you've not been through a collective consultation process before, I think the answer is consult your employment lawyer about it, and they will help you go through that process. I think the last slide, Tanya, as well, is about, yes, when could it apply? It's an aid memoir to say it's slightly off topic, but do remember that collective consultation may be engaged where you're trying to impose a change in terms and conditions on 20 or more employees. So it's not just redundancy situations, it can also arise where you're trying to impose some change in condition and you can't get agreement with the staff, and therefore ultimately what you propose to do after your consultation process is dismiss an offer to re-engage, then that may well trigger the collective consultation obligations. Okay, I'm going to hand over quickly to Ruth. We're conscious of time, but Ruth's just going to take us through top tips in minimising claims.
Sorry, it's not responding. I can't seem to get back to you. Hold on.
We can hear you. Okay.
Oh, can you? Oh, here we are. I'm back. Right. Good. Well, thank you, Linky. Some scary stuff in that section, but I'm going to try and end on a positive note. It is quite possible to undertake a redundancy exercise and do it fairly and without claims. Obviously, I'm just going to recap on some of those points to remember to follow a fair and reasonable process and minimise your risks. So having a good plan at the start is the foundation for a successful redundancy programme. Consultation is key. Make sure communication is clear and the rationale and the decisions for what you're proposing are justified and allow enough time. Remember, a tribunal won't interfere with the company's reasonable business decision if it is a genuine redundancy situation. So, and in relation to selection pools, consult employees or unions if you have to do that. Be open-minded and again, be prepared to justify your decisions. Selection criteria, the watchwords there, as we've discussed: transparent, fair, objective, and obviously not discriminatory. Make sure you keep records of your decision making and your rationale. Scoring issues, take great care with the managers who are doing the scoring and then reviewing the scores, particularly where there's any scope for subjective interpretation. And just when you're thinking about the relevant managers, do consider how long that manager's worked with a person and the right person doing the scoring. And finally, suitable alternative employment. If in doubt, put the position to the employee. Let them choose whether it's suitable or not, because you're not them. You don't know what their personal factors are. They may want to change. And remember to record that you've discussed suitable alternative employment with them. Next slide, please, Tanya. So when to engage an employment lawyer? Before you start, at the outset. Particularly important for collective consultation, as Linky has mentioned. Or if you've got a disabled employee or a pregnant employee in scope, it's best to have a good strategy from the start. I've just put on the slide penalties for getting it wrong, potentially very expensive, particularly for discrimination claims where compensation is uncapped and there's a separate head of loss for injury to feelings. And obviously, where you do have a collective consultation situation, if you fail to do the collective consultation either at all or properly, there's a potential penalty of 90 days gross actual pay for each affected employee. So that is really, that can amount to a quarter of an employer's annual wage bill, which is a frightening penalty for most people. So worth getting it right. So we're going to finish with the last slide. Tanya, please. How an employment lawyer can help. Well, identifying potentially difficult issues and strategies at the outset can make the whole process run more smoothly and avoid expensive claims, which also involve tying up your management who cannot be focused on the business as well as dealing with claims. So I've listed on the slide some things that we can do to help. And for somebody that's facing, tough times and difficult decisions, it can be invaluable to have somebody check all the relevant documents, be a sounding board and a critical friend for the proposals, especially the selection criteria, and also to provide expert advice and strategies on problem issues. When we sit down with clients to do this planning exercise, it's surprising just how many realise that they'll have to expand their proposed timetable just to fit all the meetings in. So the other point to just bear in mind is that employers are increasingly judged by their millennial employees on how they deal with difficult issues such as redundancies. So it is important from an employee morale perspective to get it right. Otherwise, you can subsequently lose staff that you'd rather retain. So I suppose the final message is expert advice and planning can save money in the long term. It can enable you to manage the redundancy process with integrity and minimal disruption, so you can get back to focusing on your business again. So that concludes our presentation for today. Linky and I will be very happy to take any questions.
Thanks very much. Thank you. I see that there are some questions. Charlotte, I think we've addressed the last in, first out issue. Kishore asks, is there an example of a non-disclosable material? I'm not sure I follow that. Kishore, I don't know if you can be unmuted and just let us know what you're thinking. We'll maybe come back to that. Tanya, if you can find Kishore maybe and enable him to come on the mic and sort of just expand on that. But Kritika asks, when it comes to disability, should the employee have had to have told us about the disability beforehand? Well, it's right that in order to make reasonable adjustments, you do need to know about the disability. So yes, I think the thing that employers have found difficult is that it's sometimes something that only comes out at the point of the consultation meeting. And at that point, I think you do have to properly engage with it. You are then on notice. Knowing about a disability is a huge body of case law because they don't have to say, I suffer from a disability. They just have to have some health issue. And it's quite rare because in order to be disabled under the Equality Act, it has to have a substantive adverse impact on their day-to-day activities. And for that, it's likely that the employer would have gained some knowledge of a health issue that an employee was suffering. So it's a relatively low bar in terms of what knowledge an employer needs to know before they're deemed to have sufficient knowledge to engage their obligations under the Equality Act for a disabled employee. But in broad terms, yes, you need to know that that what their health issues are. Maybe not that it's a disability. I always sort of say, well, a disability is a relatively low bar to overcome. You don't, for instance, in mental impairment issues, need to, fall under one of the World Health Organization categories of a mental health condition. Nowadays, it's sufficient if you just satisfy the definition of a substantial adverse impact on your day-to-day activities, sleeping, walking, talking, concentrating, which is due to last for 12 months or more, or is likely to last for 12 months or more. And even more complicated, you have to discount the impact of any medication or treatment like counselling, and sort of try and assess, well, what position would they have been in if they weren't taking that medication. So I think it's quite a low bar to satisfy the definition of disability, and it's quite a low bar as to what you need to know about it before the employer is imputed with knowledge on it. I hope that helps. Kishore, is there any clarification in relation to your question?
Yes, can you hear me now?
Yes. Loud and clear.
Yes, you gave an example, a very good example of a CEO sending out an open email saying Fred should be made redundant. That is the disclosable material. So as opposed to how should he have done it so it doesn't become disclosable?
Well, he writes to his employment lawyer and say, I want to make Fred redundant, and that's a legally privileged communication. And the employment lawyer would write back and say, well, you know, what role does Fred do? You know, it's roles that are redundant, you know, not individuals. You've got to make sure that you fairly select individuals. If there is in-house legal, then in some circumstances, a communication where you're seeking legal advice from the internal legal advisor. So if you write to general counsel and say, you know, we need to make Fred redundant, could you give me some advice about it? Then that may be covered by legal professional privilege, even if it's an internal one, if you're seeking advice from the individual in their capacity as your in-house legal person.
Okay, so talking to a legal advisor, whether in-house or outside employer, is actually privileged.
Yes.
What if the CEOs decided to have an informal meeting, which was not then recorded, so there was no communication, it was just verbal? Would that be privileged?
Sorry, with their in-house legal advisor, or
No, just with the staff, or not with the employees who are going to be made redundant, or with the managers.
yes, no, it wouldn't be privileged. No.
Okay, all right, okay. Thank you very much. I think you clarified that really well. Thank you so much.
You're very welcome. Do we have any other questions? I'm conscious of time, and I'm sorry that we sort of ran slightly over. Those are all the questions I can see. Tony, have we missed any?
No, that's fine, Linky.
Fabulous. Thank you all very much. I think we'll be forwarding a copy of the recording and a copy of the slides, but obviously if anybody wants to chat through any issues, Ruth and I are available and be delighted to chat it through.